Good, hello, good evening. This is Rahmaan, the author and founder of the Child Support Hustle and the Reform Child Support Now movement. I hope everyone is doing well today. I'm doing just fine. Had some little stuff happen today, but it is what it is. I'm happy to be here. Hey, Steph. I hope you are too. So, as the title says, thanks for joining me. Of course, I'm gonna say it. Give me a thumbs up, like, even though you haven't heard what I'm gonna say, but it's gonna be good. So, yes, my 8-year anniversary, November 13th. It's been 8 years since I've been advocating for child support reform. Whether you are new here or whether you've been riding with me since day one or year one, I want to thank you for your support. And just thank you so much. We have gotten some reforms, or there has been some things that have happened over the years. I'm just going to go over what I'm going to talk about today. I'm sorry. As y'all can see, I'm back home, and like I said, today was kind of busy. A lot of unexpected things happened, but I was determined to get on live today, so that's why I'm here. So over the years, I've seen the federal government release some reports and implement changes in the child support system, but many contain policies that have already been implemented when the system was reformed under Clinton in the late 1990s. A couple of correspondences or communications that were critical to the reformation of this diabolical child support system include the Department of Justice letter that was released in 2016. It was later repealed in 2018 by the former Attorney General Jeff Sessions. That letter, I know you guys hear a lot about it. Some of you do, some of you don't. There's a letter that was released, and it was phenomenal. It had a lot of issues covered, like bail reform, child support, things in there to do with child support. There were a lot of issues in there covered. Well, after Sessions repealed it, it disappeared off the internet. There are still copies floating around. I have a copy. It's in the description. The reason why that letter is still important and still valid is that it cites or references a lot of court cases that show that how the system, like bail reform, child support, when they use contempt of court without deciding someone's ability to pay, things like that, how they are illegal or unconstitutional. So those case files are still relevant. So that's why, even though they try to, and they did take the letter off of the internet, it's still floating around and it's still valid. So check that out. Greetings, classified. So, like, it was fighting against debtor prisons. I should have just looked at my notes and then I wouldn't have been fumbling and stumbling. I don't know why I go, of course. But the letter includes fighting against debtor prisons, bail reform, and courts being prohibited, excuse me, from using arrest warrants and license suspensions as a means of coercing the payment of court debt. And I put that link again in the description, so check that out. The second change in policy was quite significant because it reiterated the protections and rules that were already in place for parents when they became involved with the child support system. So as always, hey Ra, the letter is the DOJ letter. It was issued in 2016. The link is in the description, classified. Thanks for joining. Don't forget, like. So where was I? These changes mainly involve the low-income and incarcerated parents. Now, what I want to say real quick is that when I released my book, The Child Support Hustle, and started advocating publicly, there was not a lot of information out about child support and as it pertained to low-income parents. There was a lot of, or some information, or most of the information that I came across had to do with married parents that were divorcing, and child support issues were involving those couples or those splitting couples. There wasn't a lot of information about Title 4D funding and the child support system being a welfare recovery program, assignment of rights over to the child support or the state in order to get TANF benefits, temporary aid for needy families, those benefits, like that stuff wasn't there in abundance like it is now. So you had to really search for it. So now that this information is out there and our voices are being heard, we have to like give, say, that we did a great job getting the information out to the people and getting the legislators, the people that push this system to recognize we know what you guys are doing and we're not having it anymore. And that's why these things like the DOJ letter and this next piece, I'm gonna talk about the final rule, which is the flexibility, efficiency, and modernization of child support enforcement programs, have been released. Like other things I'm gonna talk about, but that's why they are doing this, because they have been pushing this illegal, unconstitutional system since the 90s, going into the 2000s, and they weren't saying anything, and so you just kept hearing this deadbeat. But the people that were mostly being affected was low-income people, unmarried, low-income parents. So that's what came to the forefront, is that who was being affected, and who were being really affected were the children of parents like myself. So that was just a little side note. So now they're paying attention because they have to, because we pulled the coat on the hustle. Like, we know what y'all are doing. We know about the money that y'all are getting. We know about the incentives. We know about Title 4D. We know about all that stuff. So what's going on? We know about the Bradley Amendment. We know about it. So what are y'all going to do about it? Because y'all are violating people's rights. So the Federal Register, which is a daily publication of the federal government that shares proposal and final administration regulations of federal agencies. So some of the topics that's covered in the publication are how imputing income is not permitted, ability to pay must be considered in contempt of court cases, etc. Now, this is in a final registry, but this stuff was already there. This is what they should have been doing all along. And I said this very early. If they just followed the guidelines that had already been written in the child support reformation, we wouldn't have the mess and all what we have now in the system. Because the stuff was already written, the states and the child support enforcement, the judges, family court just refused to follow it because they had no accountability. It was get money. That's it. They didn't care how they did it because it was a cash cow. Nobody was watching. Nobody was saying anything. They could just do whatever they want. And they did that for 30 years. So they're covering topics that we already know. You shouldn't be ordering a child support order for somebody to pay money that they can't afford, which they weren't doing to married divorcing couples. They really based that on their income in most cases. Now we're talking years ago, not now, because they started running amok. It was money, it was free money. Well, it wasn't free because it cost some parents their lives. But we know freedom, money cost their children, because they just went bananas with it. So let me see. So these are just a couple of publications that have been issued. But if you look at what was issued and what there were previously, nothing has really changed. The feds are just making it look as if they had no idea the states were operating in this illegal and unconstitutional manner, and they are attempting to change some of the guidelines. So they do this, and they'll pass up this stuff, put it out. Oh, we're doing this, we're doing that. But like I said, they're just repackaging it and trying to sell it to us, but we're not buying it. We want real significant change, real reform, one of those being the repeal of the Bradley Amendment. The Office of the Assistant Secretary of Planning and Evaluation and a private company called MEF Associates. They discuss possible research topics for the next generation of child support. So they're going in to the kids' generation, to our children's generation, how they're going to do this, because we stopped them from doing what they've done to us. Now they have to revamp it because we, pulled their card. We exposed them. So this report was published in 2018. So it's strange, wink, wink, that the government hasn't done more with the publication and research, not to mention the real life stories that have been presented to them from parents and advocates, that they haven't moved faster to implement the basic policy changes that they mentioned. I'm gonna tell you what they mentioned later, but implementing the policy changes would only mean that caseworkers and the overseers of the child support program would have to follow guidelines already in place. So they say, oh, we got to do this or that, and we have to research this or that. So they're just prolonging the inevitable, which is follow your own guidelines. So they're making it seem like they have to do all this and research that and survey this just to follow what's already written. And I think, this is just my opinion, admitting that this stuff is already written is going to open them up to lawsuits costing, I don't know how much, billions of dollars. So they have to make it seem like they had no idea or this stuff wasn't already there. So what better way to do it is say, oh, let's introduce it like it's not there. So implementing the policy changes will only mean that caseworkers, okay, I already said that. One issue mentioned in the publication is how to adjust child support orders in response to changing family circumstances, modifications, right? We always talk about modifications. That's a big topic, especially during COVID. They should have canceled all child support payments during COVID. When everything was locked down, they should have just did it automatically, but they didn't. Even though the courthouses were closed, child support agencies were closed, everything was closed. Everybody still expected paying parents to pay. Even though pretty much the world shut down, the only thing that they wanted payment for was child support, which was some bullshit. So according to the publication, the following changes can change family circumstances over time. Employment status adjustments in which parents are paying in child care costs, and shifts to custody arrangements. We know that. See? They don't mention disability status or illness, incarceration, although they know that, and included the global pandemic. But all of these situations would and should qualify as a reason for a downward modification. The report says the parents are legally entitled to a review of their order every 3 years. They don't tell parents that, and they act all crazy when a parent applies for a modification because they really need one. Oh, you can't get that modification or whatever, but a parent can request anytime that they have a change in circumstances. You would really think parents are asking for one of these caseworkers' right arm when all they're doing is asking for a modification because they lost their job, or they're not going to be able to work because they're sick. They're newly disabled. They've been declared disabled by, let's say, the VA declares somebody disabled. They can't work anymore. These child support enforcement agencies do not even want to look at the paperwork. It's coming from another agency, a government agency, and it's not good enough. That is insane. Most parents and people fighting for change within the family court and child support systems know all too well that child support modifications take several months and even years to process once submitted. That's a huge problem, and it has been for years. I can say that every person that I've spoken to over the years had a valid reason, and I mean, show me paperwork, they're not like a valid reason for filing for a modification, and more than half, if not more, were denied after waiting for long periods of time. When I asked them, well, did they give you a reason? Why did they deny it? Most parents said they were not even given reason why they were denied. Then they have to go through the process of finding out what, well, asking. And then they're treated like they stole something. You have a right to ask, why are you denying my request? Somebody's at my door and I can't see my camera. I'm gonna have to edit this part out. Thank y'all for joining. Like my what's the name? Hold on one sec, please. I'm just gonna edit. Okay. Yeah, I'm live. Okay. Sorry about that, guys. My daughter. Y'all always see my son come in. That's my baby girl. The reason for the child support hustle. Okay. Where was I? Okay, so keep in mind that once the modification is denied, the parent is responsible for all of missed payments that they missed, all missed payments, while waiting for the response to lower the payments that they can't afford to pay, which was the reason that they filed for the downward modification in the first place. Thank you. Okay, so that was a lot. I said that on purpose, but they get denied. They have to pay the debt that that adds more money than what they could afford to pay. They get denied, and now what is the reason for the modification if they couldn't pay in the first place? See, it's just and it's designed to drive you crazy, put you in debt, and just keep driving you nuts because you don't get any resolution. And then here you are, your kids are 40 years old and you're still $100,000 in debt. I'm gonna tell you why that is. I found something out today. I'm telling you, it's something new all the time. The government does not care that parents can't afford to pay child support. They want parents indebted to the government, and it's clear in the modification process. Collections on arrears is one of the performance measures that ensures that states receive incentive money from the federal government, right? But the incentive money is not received for total arrearages collected. I always thought that that's what they got. The states received that incentive money for was the total amount that they collected in arrears. But according to the Congressional Research Service, the performance measure counts paying cases because states have different methods of handling certain aspects of arrears cases. So states can consider things like the ability to write off debt that is deemed uncollectible. Most states charge interest on arrears, which is considered additional arrears. Former Title IV, okay, listen to this, guys. Former Title 4D cases with arrears collected from income tax offsets do not count as an arrears payment unless the state shares the collection with the family. So, all you parents out there that have a Title 4D case, meaning that the custodial parent does or has received welfare benefits, if your income tax refund has been offset and the custodial parent doesn't receive any of that money, they will not count that towards your arrears. That is why your arrears does not decrease once they take your income tax. That's why that number stays the same, that amount stays the same year after year, because they don't consider, if they're not giving them money, they don't consider it as an arrears payment. Where that money is going, I have no idea. I just found this out today. If states do not attain a rate of at least 40% in this arrears, and their arrears little scheme, they are not eligible for incentive money. That's why your modifications aren't getting processed. It's not even about them. You hear what it's about. So now we know specifically why they don't want to grant modifications and why they purposely take forever to process the applications. The reason that the authors posed for the lack of processing modifications and helping parents is interesting. Okay, so here's what they are proposing. I have posed, but it's proposing as a how to remedy the delay that is taken to get these modifications processed and why it's taking so long. This shit is funny. Let me see. Are you guys ready? First, they say that, quote, child support agencies have access to a large amount of data, but many times agencies are unable to use that data to their full potential due to aging data systems and limited resources for improvement, end quote. Are we to understand that the federal and state governments have all of the data on everyone that they want to, especially those with child support cases, but they don't have adequate technology and they don't have money to modify cases, to process modifications? They don't have the technology to process modifications, but they can locate parents' employers. They can garnish wages. They can report child support debt to credit bureaus. They can deny and revoke passports. They can suspend drivers' recreational and professional licenses. They can offset federal and state tax refunds. They can garnish stimulus money or offset stimulus money. They can issue liens on property and bank accounts. They can issue arrest warrants. They can arrest someone and imprison someone. But they don't have technology to speed up the modification process. They have aging data systems. So they have all that data to do all of that, but they can't modify child support requests in a swift manner. I call bullshit. And for the record, there's only one state that did not have the mandated computer system in the United States, and that's South Carolina. According to South Carolina Social Services, after more than 2 decades, Palmetto Automated Child Support System, PAXSS, and the Centralized State Disbursement Unit are finally operational statewide and federally certified. That was in September of 2019, and that ended substantial federal penalties. South Carolina was the only state being penalized for not having their computer systems up to date. So everybody else had functioning computer systems and technology to use that data to help out parents and not screw them around when it came to, not processing their modifications. But they're saying whatever they want, because if not, I think they'll get sued, because this stuff is already, like I said, it's already written in the guidelines. So this means that every other jurisdiction, as far as the resources, now y'all know that's some nonsense. I'm not going to talk about the incentive money that states receive. that should be used to improve the modification process, or the fact that more than half of the states refuse to pay 100% of the child support to TANF families, and focus on the TANF block grants that states are allowed to keep and spend on whatever they want. It does not have to be for the children, and it obviously isn't used to streamline the modification process. According to the Center of Budget and Policy Priorities, many states have the flexibility over the use of state and federal TANF funds to divert funds away from income support for families and toward other state budgets, often unrelated to TANF goals. This is so they say they don't have resources, and modifications help the paying parent, and they also help the children. So this is critical. If people choose to use this system, and I say choice because, you know, I feel, and it's been proven, that child support is voluntary. It's only mandatory if you apply, or the custodial parent applies for welfare benefits. They're mandated to sue for child support. So if this is you choose to go this route and go in the child support system, it's important to know, like, the TANF funds, where they're going. So for instance, they say they don't have money to, if you need a modification, to process it quickly, you know, so where's some resources? So in 2019, states spent only about 1/5 of the funds on basic assistance to meet essential needs of families and children. Some 14 states spent less than 10% on basic assistance. Some states spent less than a third of their federal and state TANF dollars on work activities, work supports, and supportive services and childcare. States used almost half of federal and state TANF dollars for state services, other than helping families meet their basic needs. So to put this in perspective, like the money amount that the states have been allowed to keep, and they don't have to use this TANF money on TANF. They can use it on anything in their state. So why wouldn't the states that already get a lot of money from the child support system in itself? They get feed money. They get, you know, like I said, I wasn't going to go there because I was going to talk about this in particular. So to put in to perspective how much money these states have on reserve of TANF money that could be used as a resource. In Texas, and this is in 2019, Texas had accumulated $330 million in unspent TANF block grant funds during that year, and they can carry it over. So I don't know what it is now. California, during the same time, had accumulated $259 million. And Ohio, Buckeye City, that's my state, my home state, they had accumulated a whopping $582 million. Wow. But the people that are writing this policy saying that we need to research this, we need to, you know, see what policies we need to have in place, are saying there's no technology and there's no resources. Y'all know people that hustle people, you know, there's good hustling, there's bad hustles. You know, this is child support system is a bad hustle because they're robbing people. And so here you see it. So the people that are writing this stuff are going to act like there's no resources and no technology, like we're stupid. And all you have to do is look it up. But you don't even have to. I'll do it for you. Just make sure your notifications are on. So when I go live, because I'm about to break all this stuff down, so y'all know to call them out on it. This is already there. You're not doing anything. When they say that they want to streamline modifications or something like that, you let them know y'all already are supposed to do this. Do something that needs to be done, like repeal the Bradley Amendment and erase all the child support debt owed to the government. Y'all wasn't supposed to get that money anyway. That money is supposed to repay the government for welfare. Welfare benefits are grants, not loans. Second, non-custodial parents did not sign a contract to repay any welfare benefits. Let them know. That's all. This is information that you can use to clear yourself from this nonsense. So I want to be clear. When I started fighting against the system, I never expected change to happen overnight. 8 years ago, people weren't really discussing child support and the effects of low-income parents and Title 4D and custodial parents' cooperation with child support mandates. So just to hear and read the slightest acknowledgement from legislators and policymakers that the system is not working means that our voices have been heard. So the spotlight is shining on them, and they know we're watching everything that y'all doing. It shows that even the most corrupt government systems, that we the people can force change. It can happen even if the change is slow. Even when they refuse to hold themselves and each other accountable, we can hold them accountable. And that's important when you see any system that's doing wrong. I mean, you got to keep at it, because this is a multi-billion-dollar a year industry. They were not going to give it up smooth. And they still going to keep kicking and screaming. They're going to keep fighting. And we just got to keep fighting. We can continue to call them out on their nonsense, just like them telling us that they don't have computer systems and resources to effectively process modifications. They can establish the hell out of a child support case when they want to. They lose fast. They churn those out. The default judgments, they just rubber stamp establishing the child support order. When it comes to modifications, they don't have the resources. It just doesn't make any sense. So we here to tell them, y'all can think that y'all pulling the wool over our eyes, but y'all have been exposed. So I just want, so I know around the holiday times, it's very difficult for some parents, especially alienated parents going through the family court system, the child support system. It can be difficult to cope around this time. So I wanted to give out some information, some phone numbers. First, the one to Suicide Prevention Lifeline. I'm going to put the links to their websites in the description as well. The Suicide Prevention Lifeline phone number is 800-273-8251. Hold on one second. I'll cut it off. Okay, let me say it again. 800-273-8255. And then the VA has a number for veterans for the suicide prevention line, and theirs is 800-273-TALK. Oh, okay. I guess they have the same number. I just recognized that. And then there's a substance abuse and mental health service hotline. If you or somebody, your loved one or somebody you know is in distress during this time or any time, it's 800-662-HELP. And that's for help 4357. That's 800-662-4357. So let me look at the comments real quick. Right, Donald, due process is very important. If you were not served the child support complaint, the original child support complaint, and they went on and found you in default judgment or something like that, that case is bogus. File to get it terminated. Voluntary, yep. Thanks, Steph. Don't forget, remember, like the video. Even if you're watching this later, please click the like button. Don't forget to check on your loved ones, your friends. If you know they're over there by themselves and, during the holiday, make sure you check on them. Yeah, there's just a lack of privity of contract. Is that what you're saying, classified? Yeah, that whole contract thing, like that's not putting somebody on child support. That non-custodial parent did not sign a contract to receive those benefits, to pay back those benefits. It's based on a common law theory. And I wrote an article breaking down that common law theory and how it's affected how the child support system has implemented into this whole thing. And you can find that if you go to the childsupporthustle.com and just type, or go to Google child support hustle common law, the article will come up. And I break it down, I think, pretty well, and explaining how they figure that they have a right to force a non-custodial parent to repay welfare benefits. Oh, and if you want to sign the petition that I send out pretty frequently on Twitter to the Biden administration to erase all government-owed child support debt, you can find that and other information on my link tree, and that's in the description as well. If you want to purchase my book, it's available in print and digital. You can get this at thechildsupporthustle.com on my website. I appreciate you. Thank you in advance for your purchase. And let me see, I think that is it. I want to thank you all for joining me. I know I was kind of stumbling and bumbling. I'm just getting home, and this is my first live, so just trying to get situated. And I just wanted to come on here and say hi. And I definitely want to get the information out about the suicide hotline and everything about just what I talked about. Be prepared, because they're going to put out a lot of information like they doing something hot and fancy and new, but really they're just putting out what's already there. What was that? Is that Brandy? Brandy. Hi, Brandy. How are you? Brent, thanks for volunteering to send the letter. I don't know if you've gotten any responses, but I would like to know if you did, and if you had any follow-ups. If you want to volunteer to send our letter, Attorney Cassandra Daniels and I prepared a letter, and we're asking for volunteers to send them to your legislators, local, state, and federal. And there's four of our own proposals in that letter that we think would significantly change the child support system. So if you're interested, just send an email to me, cshustle1@gmail.com, and put letter in the subject line, and I will send you a copy of it. And then, of course, you can add whatever you want in the email when you send it out. If you feel like something should be added, or, your own comments. Yeah, that is where the law resources. Citations. What do you mean, the law resources and citations? I don't know what you mean, classified. It's hard for me to read this because light is shining right in my eye. So if that is it, you guys, and of course you can always email me, cshustle1@gmail.com, if you have any questions. I will gladly respond. I don't work on individual cases anymore, but I will, if I have the information, I'll try to point you in the right direction. If I can help you, connect you with some resources that I have, I will gladly do that. And I'm pretty sure I put that DOJ letter in the description, but if I don't, I'm gonna double check and make sure it's there. And I also have a ton of articles on the childsupporthustle.com that you can use as a reference. There's a ton of citations there too. Is that what you in your book you cited some law reviews? Oh yeah. Oh yeah, I did. I researched that book. How my book came about is because I was trying to close my case against Ohio with all their 500 and something $1 million. And so that's how I found out about this corruption. And I actually put our court documents in here from when they finally closed the case. So, and that was prepared by an attorney in Franklin County. And that took me, for anybody that's unfamiliar, that took me 8 long years of fighting these people to get my case closed and the arrears erased. They did not want to do it. And I am the custodial parent, not knowing what I was getting into for those benefits. So okay, guys, I'm gonna get off of here. It is a pleasure to be on here with you, and I thank you all for sticking with me. You know, sometimes I can get it out smooth, and sometimes I fumble and bumble, but you guys held in there with me. I appreciate you so much, and thank you for subscribing. Thank you for I'm not on Facebook that much anymore. I still post and I still answer the messages, but not really. If you're on Twitter, come follow me. I'll follow you back. On Instagram, same thing. I don't really follow back if you have a private page, just because, you know, that's too much for me. But on Twitter, just follow back. And yeah. So y'all remember, they can ignore hundreds, they can ignore thousands, but they cannot ignore millions. Let's go.